Members, good morning. It's the appointed time and we have a quorum. I'd like to call to order the meeting of the Bills Committee on Private Columbaria Bill. I think we know this very well already, but I'll just read it out. According to House Rules 22 and Schedule 4, we need to elect a chairman. We need to have a nomination. A valid nomination must be made by a member orally, to be seconded by at least another member orally. And it should be accepted by the member nominated. May I invite nominations? Dr. Priscilla Leung. I nominate Mr. Gary Chan. Any seconder? Which one? Mr. Tommy Zhang. You second? Okay. Mr. Gary Chan, do you accept nomination? I do. Any other nominations? Mr. Nathan Law nominates Ms. Tanya Chan. Any seconder? One. Who? Oh, you're not a member. Here he comes. Mr. Ray Chan seconds. Ms. Tanya Chan, you accept nomination? I do. Now we have two nominations. Number one is Mr. Gary Chan. Number two, Ms. Tanya Chan. I'll now ask the staff to distribute ballot papers and also the chart.
I'd
like to remind members that you should check the box against the nominee you desire. Number one is Chan Hak Kan. Number two is Tanya Chan. Since this is a secret ballot, please do not show your ballot paper to others. Please fold up the ballot paper. You do not have to fold it again. Is it that every member has got a ballot paper? If you don't, please raise your hand. If members have all got a ballot paper, please proceed to vote. How many papers have you distributed? We distributed a total of 22 voting papers. If there is no question, the staff can now collect. No more ballot papers will be distributed. If there is no question, the staff will now collect the ballot papers. Sorry. I have already announced that no more ballot papers will be distributed.
Have all members put your ballot papers into the ballot box?
If there is no question, we'll start to count the votes. Mr. Tommy Chang and Mr. Ray Chan, please come forward and supervise the counting of votes.
係咧，個監票啊嘛。係監票，因為提名係啦。啊，所以分提名。
Sorry, it should be Mr. Tommy Chang and Mr. Nathan Law. They are the nominators. Sorry about that.
我哋唱票咯，佢哋唱票啊，唱票，係冇錯。2號
Number 2. Number 2. Number 2. Number 2.
1號
Number 1.
1號
Number 1. 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 Mr. Gary Chan has 18 votes. Ms. Tanya Chan, 4 votes. Mr. Gary Chan is elected chairman. Congratulations.
好，好啊，少唔少？多謝同事嘅支持啊！
I'd like to thank members for your support. Now I'd like to ask you whether we need to elect a deputy chairman. Yes, Mr. Leung Chee Cheng, you think so? Mr. Paul Chair? Sorry, speaker not coming through. Can I have a nomination then? Mr. Nathan Law? I nominate Ms. Tanya Chan. Any seconder? Mr. Tommy Chang. Ms. Tanya Chan, you accept nomination? I do. Any other nominations? If not, since we only have one nomination for Deputy Chairman, I declare Ms. Tanya Chan elected Deputy Chairman of the Bills Committee ipso facto. Congratulations, Ms. Chan.
OK， 好，好。嗱，未開始傾我。
Before we go into the agenda, I have received a letter from Mr. Shoka Chun. He has not been able to give an application before the deadline, but he'd like to join the Bills Committee. Any objection? If not, welcome to you, Mr. Shiu. You're now a member. Next, I think we should invite the administration team to come in first.
得，我哋到時叫政府介紹，我有個 PowerPoint。主席，我哋都收到有個意見書，咁如果你同意，我哋就就係而家 table 俾啲委員。好啊，你俾佢哋。好啊。就嗱，各位同事。
Members, members attending today's meeting, we have a number of officials and the list has been tabled and I won't read through it. As you know, the bill was introduced into LegCo in 2014 and a total of 35 meetings of the Bills Committee were held and members put forward 547 CSAs. All these CSAs have now been incorporated into this blue bill. Therefore, the content of the bill has been discussed many times. Now I think it's time for the administration to help us refresh our memory. And in fact, we have new members here. I think the administration should nevertheless walk through the bill so members can ask questions. Now I'd like to ask Mr. Daniel Chang, DS for Food and Health, to walk us through the bill, please. Can I defer to Ms. Diane Wong? Yes, certainly. PAS for Food and Health, would you please walk through the bill for us? Thank you, Chairman. Thank you, members. Thank you for giving us the opportunity to introduce the bill to you. Many members are here for a second or more terms, but there are also some new members, so we'll take the opportunity to refresh your memory together. 2.5 years ago, the bill was introduced into the Legislative Council for the first time, and 35 meetings were held over the last 2.5 years, and the Bills Committee agreed to a total of 547 CSAs. As you know, the discussion was comprehensive and in-depth and thorough, and we are proposing the bill as agreed into LegCo. There are 11 parts and 7 schedules to the bill. Stakeholders would all want the bill to be enacted fast in order to tackle historical legacies. And we like to strike a balance. That is why we like to launch a licensing system in order to regulate private columbaria. Our objectives are to make sure that the private columbaria will comply with statutory and government regulations, 2, to protect consumers, and 3, that the sector can operate in a sustainable manner. Under the licensing system, the private columbarium would need to have some specified papers, either is a license or an exemption or temporary suspension of liability or TSOL. It has to have one type of such specified instrument before it can continue to operate, and only licensed private columbaria, whether they are existing ones or new ones, will they be able to sell interment rights. This is important because to consumers, once there is a licensing system, consumers will only patronize licensed columbaria. Now consumers don't know what to do because they do not know which columbaria will eventually get a license.
Next is licensing system. This is a very important system. Whether it's a community or the Bills Committee, they have come with some sort of mainstream views. They think that we should be adopting a compassionate and pragmatic approach in dealing with pre-cut-off columbarium, which is a historical legacy, or else there will be some 380,000 niches which would have to be displaced. Now, for each niche, there may be several sets of ashes entered. So the problem can even be more serious. So if we don't deal with the problem properly, then that will the society will have to pay a huge cost. Now, very often when the government introduces new legislation, there is this usual approach, and that is there are already many existing operators. In order that existing operators and consumers will not be affected too much, well, a usual practice is whenever we introduce a bill or a new law, there will be grandfather arrangements. We have the same arrangement this time, but I must emphasize that they are exempted from certain provisions only. When the new law comes into effect, certain provisions will also apply to existing operators, and a very important cut-off time is when the bill was announced. So we would maintain that cut-off time. At that time, we have launched a notification mechanism, and we have taken some aerial photos to get a grasp of the snapshot situation at that time. As I mentioned about 3 specified instruments, after or before the cut-off time for operators which were already in existence and where there were niches where ashes have been entered, then we will consider them as pre-cut-off Columbaria. And the decision will be made by the licensing board. Well, there are different implications for pre-cut-off Columbarium or otherwise. If they are not pre-cut-off Columbaria, they can only apply for license and not TSOL or exemption. But if they are pre-cut-off Columbarium, then they can apply for license, exemption, or TSOL. Well, let me now talk about the licensing system. Now, before I talk about the licensing, I must emphasize that only licensed Columbaria can sell niches, whether they are pre-cut-off or non-pre-cut-off Columbaria. Well, we have certain eligibility criteria for them. Even for pre-cut-off Columbaria, they must meet a certain criteria. But then, since this is still a historical legacy, well, we will have some flexibility and discretion, and that is also accepted by the Last Bills Committee. Now, if a Columbarium wants to apply for a license, it must meet with provisions in the bill, planning provisions. It must meet with Cap 131 Town Planning Ordinance's provisions. Second, it must meet with land-related requirements. If it doesn't meet with the requirements, it wants to apply for regularization, it must pay a land premium. And the third area is building-related requirements. Put simply, well, they must meet with Section 14 of the Buildings Ordinance, i.e., they must get Section 14 approval from the Buildings Authority before building certain structures. And some provisions may not apply here. For example, small houses in the new territories. But you cannot say that they have breached the building ordinance. So it comes with its own exemption mechanism. For example, small houses are exempted. So we will go by these as standards to see whether they meet with the buildings ordinance requirements. We also have flexibility in building ordinance requirements. If they are pre-cut off Columbaria, they have illegal structures. But if they are certifiable structures, and meet certain requirements as long as they are certified by the AP or registered structural engineers to be structurally safe, and they have been vetted duly by the licensing board, which may say impose additional conditions on them to make the structure safe. Then these structures can be kept. And also for its premises. As we all understand, when consumers buy niches from these Columbaria, they want the niches to be there on a long-term basis. So we want the operators to hold the premises or land for a long time, so that we have this requirement that the premises are being held directly from the government under a lease. Maybe a structure has been built on the site and the titles have been sold off and there are divided shares on the land. So these have to be also covered under a lease. For pre-cut-off Columbaria, if the applicants can prove to the licensing board that they have the right to use the premises for at least 5 years, then their application can be considered. And third, say in their course of operation during these the worship seasons, we will pay attention to the traffic flow, the visitor flow, and so on and so forth. And so we require the applicants must submit a management plan for the licensing board to consider. So we hope that this can address concerns of the neighboring residents. Fourthly, we are doing this in response to members' request, because some of these Columbaria are in multi-story buildings. They come with deed of mutual covenant. So if the DMC forbids the area or the different floors to be used as for commercial purposes or Columbaria. No, so how will we deal with that? We have taken reference from what's been done by the HAB. They have done certain consultation as well. So if there is such restrictive clauses in the DMC, then they think the licensing board should take into consideration this. So we've added a fourth point. That is to say, if the DMC is enforced, the applicant must submit a written legal advice of a legal practitioner confirming that there is no express restrictive covenant. Then, only then will the application be considered. Now, second has to do with the exemption. I must emphasize again that during the exemption validity period, no niches should be sold off. Only pre-cut-off Columbarian can apply for exemption. If the Columbaria do not wish to sell interment rights, and then the residents are maybe more willing to accept the status quo. So the pre-cut-off Columbaria can apply for an exemption to continue their operation, so they can still manage the ashes already interred there. Now, the eligibility criteria would be more lenient than those in exemption. But then we still have very stringent requirements. The number of niches and also the layout distribution of the niches should be kept as the same condition when they applied for the application. So there should not be any additional number of niches. In response to the community and legislators' views, well, they've told us that what about the niches already sold at the time of the cut-off. Now, in the last Bills Committee, we said that some consumers were asking what would happen if the interment rights have been sold off at the time of the cut-off time. So what would happen to those? So in the latest bill, we added in a provision that for niches sold off before the cut-off time, the interment can still be done after the cut-off time. Well, we don't know who will get the exemption. So the spirit of the law is that these operators should have the ashes interred as soon as possible. So we hope that the operators can proceed with the application procedures as soon as possible, i.e. applying for exemption. And next, who can apply for exemption? The main criterion is that they must have, say, been operating for a long time already. And our bill is that if they have commenced operation before 1st of January 1990, then they would meet this criteria. So it means that they have operated for over 25 years, and the society may very well accept that this is a reasonable cut-off time. Second, they must stop selling the interment right after the cut-off time. Well, since they are pre-cut-off Columbaria, we hope that they can hold the land directly from the government under a lease. But if they can't do that, so long as they can prove to the licensing board that starting from the cut-off time, they can still use the premises for at least 5 years, and they can apply for exemption. Fourth, they must also meet with the land-related requirements under the bill. And fifth, building-related requirements. As I said, we hope that they can meet with building-related requirements. If they can't do that, if their illegal structures are considered certifiable structures and they've been certified by AP and RSE and other requirements imposed by the licensing board, then the licensing board can consider that allowing them to keep these structures. And also in relation to religious pagoda, that was a provision added in response to members' concern. In Hong Kong and the mainland or overseas, there are religious groups who have set up temples and other religious institutions, and religious practitioners may live in these temples and they are not living with their family. So after they pass away, their ashes will be kept in the facilities in the temples. So we have to face up to this historical fact. So in response to views collected and members' requests, we have added in a new provision in relation to religious ash pagoda. If they are, say, Chinese temples, and they are pre-cut off Columbarian and have obtained an exemption, and if they meet with those provisions and also other requirements imposed by the HAB, and also there is another important factor is if they are interring ashes of the religious practitioners without any fees and charges, then they can be considered for an exemption. So the licensing board will try to deal with their application for exemption expeditiously.
But I expect them to apply to the HAB and will facilitate the submission of plans. And then the HAB will make arrangements with the relevant Columbaria. Last time, we explained that in each religious ash pagoda, there should not be more than 1,000 sets of ashes. It's not a big number, and it's quite acceptable generally. Number 3, the TSOL. As I said at the beginning, these Columbaria will not be able to sell in terminal rights, and this will only apply to pre-cut-off Columbaria. Why do we need this TSOL? It is because in the long term, Columbaria should operate under licenses or exemptions. But this is a historical legacy, and there are many of these Columbaria. We have to face reality, and there are irregularities. When they rectify the irregularities in terms of planning, land, and building works, that takes time. But we also hope the ordinance can be enacted as soon as possible so that we can enforce the law. But at the same time, if there is an opportunity for certain Columbaria to apply for specified instruments, including licenses and exemptions, will allow them reasonable time to comply with statutory and government regulations. From our contact, we know some of the operators are sincere in doing this, and we like to give them some time. In the interim, we will consider allowing them to have a TSOL so they can continue to operate instead of keeping ashes without authority. The TSOL is there really to give them time to continue to operate and then rectify their operation. But then society has said that there should not be any delay because we have dwelled on the problem for very long. If they only apply for a TSOL, that won't do. They must apply at the same time for a license or an exemption, because we want them to comply with all the requirements as soon as possible in order to get a license or an exemption. And number 3, within the validity period of the TSOL, they have to reasonably and expeditiously take all steps in order to comply with the requirements of a license or an exemption. And no internal rights can be sold in the interim. If there is any irregularity, they will be penalized. As you know, the TSOL is only there to give them time to do rectification. We like to set a reasonable threshold, which is not too high. We are giving them a deadline in order to rectify the problem, and they have to comply with 2 eligibility criteria. 1, there should be authorized persons or registered structural engineers to certify that there are no clear or imminent danger in terms of fire services and building safety. This is something that we all can accept. If we give them the specified instrument, meaning that they can continue to operate and we will not enforce the law on them. But if they exploit the time to delay and they occupy government land, as you know, there can be reverse possession if they occupy government land without statutory authority for long enough. So if we know that there is a case of occupying government land, they will have to apply to the Director of Lands in order to occupy unleased land. So this is some kind of regularization. Also, they have to supply a written statement to the Director of Lands that they can make no claim about the unleased land. In other words, they cannot claim that there could be reverse possession after a period of time. The licensing system and the validity period of the specified documents. A license, it is either the tenancy period or the remaining period of the lease, whichever is shorter. Exemption. It should not exceed the remaining period of the tenancy or the lease of the premises. Number 3, TSOL. It is a transitional arrangement. The validity period would be different from the other two. The first validity period is 3 years. But as you know, when it comes to land, building, and town planning rectifications, that may take a long time. And if there is a need, they can apply to extend the validity period. But unless there are exceptional circumstances, there cannot be more than one extension. Then the notification scheme. The Secretary announced the bill in June 2014. The FEHD rolled out this administrative arrangement, which is the notification scheme. We collected details about pre-cut-off Columbaria, how many niches there are, how many have been interred, etc. And the information will be helpful to the licensing board in considering whether these Columbaria are pre-cut-off Columbaria and whether they are eligible for applying for any kind of the specified documents. So much for the regulatory scheme. Second important point, consumer protection. This was present in the last bill, and we have added in measures in view of members' views. First of all, the operator must get a license before interim rights can be sold. And consumers will know that you should only patronize licensed operators. Number 2, we have seen contracts applying to private Columbaria. There is a whole range of contracts. Some are more regularized, some have rather informal papers. If the bill is carried, when interim rights are sold by operators, they must sign an agreement, a written agreement with consumers. And in the bill, we have listed the information, proposals, and terms to be contained in the agreement. Failing that, consumers can cancel the agreement. If they have already paid, they can get back the money they have already paid. If they haven't, then they don't have to pay. And number 3, in response to members' views, as you know, Columbaria are a long-term operation. But we have to be realistic. We can't prevent any transfer. Even if there is a transfer, we don't want to see a situation where the transferee says that the previous agreements were signed by the transferor, and then I can then dispose of the ashes and resell the interim rights. If that's the case, there can be numerous transfers, so the interim rights can be sold again and again. We therefore stipulate that in transfer instruments, after the transfer takes place, the transferee will have to take legal responsibility for all obligations and debts. In other words, even if there is a transfer, the transferee will have to take legal responsibility for niches sold. Another point also mentioned by members. Operators and consumers, of course, have opposing interests. The authorized representative, say for example, a Columbaria ceases operation, the representative can handle the ashes and also allow people to claim back the ashes. But then there could be a situation where the operators may coax consumers into appointing the operator himself as the representative. And then the operator can, in his capacity as the authorized representative, handle the ashes. since there is a possible conflict of roles, we now say the operators or his agents cannot become the authorized representative of the claimants in the agreement. Lastly, there have been cases in the past, and members mentioned this, there are old people who die, and then their sons may help them inter ashes. Then the operator will say the agreement was signed with the deceased, so you cannot execute the agreement on his behalf and no ashes can be interred. And we say in the provisions that in the agreement, authorized executors can be mentioned. And then the third segment, which is also important, proper disposal of ashes. We have had detailed discussion with the DOJ before writing this part. When the bill is enacted, all Columbaria will be covered. And people who operate Columbaria will have to act accordingly. Some are in operation, some have ceased operation. If they are in operation, they have to act according to the relevant interment agreements and keep the records. But if they cease operation, the bill stipulates clearly the prescribed ash disposal procedures, so the descendants will know how to come and claim the ashes. Now, actually, if in reality people cannot really follow the prescribed ash disposal procedures to the letter, we allow them to apply to the director of FEHD to carry out alternative ash disposal arrangements. But if there is improper disposal of ashes, that will become an offense. I'd like to let you know who needs to carry out the prescribed ash disposal procedures. The first two are really the operators. And the third one, if someone has absconded or in any other circumstances the operator is not there, the owner or a third party may take possession of the Columbaria. And these people who are person in possession should do something. I'd like to talk about the first one. If you do not have a specified instrument, you should not be operating a Columbaria. After the grace period, if this person continues to operate a Columbaria, he has the responsibility to carry out the prescribed ash disposal procedures. But if he ceases to operate because he absconds or because of law enforcement, he of course also has the responsibility to carry out the prescribed ash disposal procedures. And a third party who takes possession of the Columbaria. Let me talk about the owner or mortgagee. Maybe it's the landowner or the bank. If they take possession of the Columbarium, as we explained to the then Bills Committee, we have to differentiate between whether knowingly does this or that he is not in the know. Say if it is already registered with the Lands Registry and you still do the mortgage and you still sell the Columbarium, then of course you do it knowingly, so you have an obligation to carry out the prescribed ash disposal procedures. But if you are not in the know, then that will be the third party other than those in the above category. These third parties can be the liquidator. If a third party has taken possession of the Columbarium, we are not saying that they have to carry out the entire procedure. We give them the option so they can apply to the director of FEHD and for somebody to go to his Columbaria within 15 months. So the FEHD or specified officers can take the necessary procedure to deal with ashes already interred.
As I said, well, the specified ash procedures will be announced in the public, and people can claim back the ashes. And we have taken heed of the DOJ's opinions. Maybe people are claiming back the ashes or these articles, containers, watches, so on and so forth. Many people can come forth to make the claims. We want to extend the coverage to allow those who want to make claims can make claims. And the consumer, in signing the contract, may specify, say, that there is an authorized representative who can then make the claims, and also the estate agent, and third is relatives, and the fourth is the buyer. And in the bill, we have set priorities for these different groups in claiming back the articles. In the last bills committee, we have taken on board a number of views made by members, but there is one particular point. And there are suggestions that they say the cohabitees, fiancé, same-sex partners who are married outside of Hong Kong, etc., etc., they are not considered as spouses. And can they be covered under the category of relatives? We have explained in detail that we have given the very detailed thoughts on how to cover those situations. Now they can say claim the articles as, say, the buyer, the authorized representative, or the estate agents. Maybe they said that they would like to claim back not the ashes but the relevant articles, but then all these will be dealt with at one go. They can also make the claims in the capacity of the owners of the articles. Now, ultimately, if nobody comes forth to claim back the ashes and there are no pending legal procedures, the ashes will be handed over to the DFEH, and then DFEH can still exercise discretion to deal with the ashes in an appropriate manner deemed appropriate. And he can consider handing back these ashes over to the people that I mentioned. So there is indeed a channel for these people to claim back the ashes, and also for other procedures. The ash handlers may not have drawn up a prescribed ash disposal procedures and may not have completed it either. There is a provision under the bill to empower the public officers to take possession of the ashes and deal or dispose the ashes. We understand that if the people involved are not disposing the ashes, then the government will make the necessary arrangements. But we may be talking about private premises. So under the bill, the prescribed or the designated officers can apply for an occupation order from the court and then go into the premises to deal with the articles and the ashes. And there are different periods specified under the bill. Upon the expiry of the designated period, all the unclaimed articles and ashes will be handed over to the DFEH, who will deal with it in accordance with government practices. Now, after a reasonable period of time, the articles or ashes are still unclaimed. The DFEH can exercise its discretion to dispose of these ashes and articles in a manner he sees fit. Now, exclusions and exemptions. The bill has a wide coverage. There are exclusions and exemptions. First is the bill does not apply to a columbarium maintained by the government or a columbarium governed under Cap 132. So these columbaria will be governed under Cap 132. Second, when the bill was introduced back then, people were taking advantage of the possible loophole because ashes could be turned into synthetic diamonds, and this will not be covered under the bill. So in response to the views submitted by members and the public, we have introduced a provision to the effect that only if a premise meets certain criteria will they be not covered by the bill. Well, I mean the premises where ashes are turned into synthetic materials. The third scenario is that for certain religious groups, they will launch certain exhibitions, say in the Convention Exhibition Center, the Buddhist relics and so on. And if they meet with certain preconditions and the ashes are just for exhibition purpose for a short time, then the bill will not apply. The last scenario is in domestic premises. Even without the bill, ashes are kept in domestic premises. Now, so we give exemption back to domestic premises with around 5 containers of ashes. But then, in response to members' views, we have increased the number to 10 containers of ashes. And next is the licensing board. The licensing board is to regulate the operation and management of the Columbaria. It will consist of not less than 7 members and not more than 9 members appointed by the chief executive. Appeals board is to deal with appeals of any aggrieved applicant or holder of specified instrument. The members are appointed by the chief executive. Major offences. There are many provisions in the bill. If they operate without a license, if anyone operates a columbarium without a license, including selling interment rights, he commits an offense. For pre-cut-off columbaria, which have obtained an exemption or TSOL, and if they do not sell interment rights, then they do not commit an offense. Improper disposal or improper disposal of ashes will also be made an offense. Commencement. Most of the provisions will commence operation on the gazetted date. The community hopes that this historical problem can be resolved ASAP. So once the bill is gazetted, then it will commence operation. People are not expecting another commencement date. So most of the provisions will commence operation on the enactment date. These include restriction on sale of interment rights and proper disposal of interred ashes by operators, persons, and a specified officer to apply for an occupation order, etc. So all the provisions relating to enforcement will come into operation. But for the licensing provisions, we know that we need some time to do preparatory work. So that will be 6 months for our preparation work, and we will accept application in the 7th to 9th month. So such an exemption and a TSOL will have to be submitted after the expiry of the 6-month preparatory period. In the first 6 months, the licensing board will do preparatory work, including drawing up the application forms, templates, and so on and so forth. They have to be vetted by the licensing board. And after the 6 months, the licensing board will start accepting applications for specified instruments. And the Columbaria have to make applications for specified instruments in the 7th to the 9th month. So for the 9 months, 6 months, first 6 months for preparatory work, the next 3 months for accepting applications. We have to give also a grace period for people to get adjusted. So before the Gazetto, for existing operators operating before the Gazetto, they will have a grace period. That will be the starting from the Gazetto date to the end of the following period. Now from the enactment date to the 9 months, and that will be the grace period. If the Columbarium have submit an application for TSOL, the grace period will extend till the time when the application is accepted or rejected. During this period, the Columbaria cannot sell interment rights, i.e. during the period when they don't have a specified instrument. But then they still can operate when they don't have the specified instrument. So that's the major points of the bill. Thank you, PAS. So I believe that we understand the provisions and the legislative intent of the bill. Before I hand over the floor to members, I have to say that we have received a letter from the Hong Kong Columbarium Merchants Association Limited. It has been tabled. So I would now ask members to ask questions. Those who would like to ask a question, please raise your hand. Tanya Chan, Junius Ho, Leung Yu Chung, 3 members, and Edward Lau, 5 minutes. Ms. Tanya Chan. Thank you, Chairman. I may have a lot of questions. Maybe when we scrutinize the bill, we can go to these questions one by one. First of all, page 18 of the PowerPoint, it is said that the FEHD has launched the administrative notification scheme and has got details of the operation before the cut-off time. You talk about the layout. You will collect information on that. How did you get the information? Is it accurate? You can only get such information when you actually enter the premises. So I wonder how accurate the information is. You talk about aerial photos, but the internal operations, how many niches are there? So I would like to know more. And also, I'm concerned about consumer protection or consumer rights. Back then, well, we did. I did a lot of work on that. Well, say for example, how do we interpret human remains, ashes, whether they are considered as human remains, etc. And also the cancellation of the agreement. We've dealt with a number of such agreements. Back then, there was no law, and we didn't even know which bureau was responsible. So all we could do is to ask the consumers to read through the contracts. But then if the operators absconded, you would not be able to get a refund, which is like what happened to California Fitness. So I paid the money. Maybe the money should not be first deposited into the operator's account. Maybe I could ask the lawyer to keep it first until when the time when the specified instrument is given to you, then the money will be transferred to you. So if the operators have a financial problem, they would it would be hard for them to continue their operation. So I would have another question on page 24 on the PPT about keeping no more than 10 containers of ashes in domestic premises. What do you mean by domestic premises? Are you going by the building plan, the land lease, or the DMC? Well, looking at the undivided shares, I'm thinking about the subdivided units. Well, people can easily say take advantage of loopholes in the law. Say if I divide up the flat into 10 units, and I can store more sets of ashes.
DS. Thank you, Chair. Let me give a general response first, and then I'll defer to other departments to give detailed answers. First of all, the executive side, the snapshot. Since it is an executive arrangement, it is not mandatory. In other words, we did need the cooperation of the operators at the time, and it was done on a voluntary basis. So is it 100% accurate? We dare not say so. But we did take photos, actual photos. We went into the premises to take photos where people cooperated. So the record is quite comprehensive. As for the aerial photos, whether or not we got the consent, we took them. But of course, these photos, if taken outside buildings, were not of very much help. However, we wanted to help the licensing board to collect collaborative evidence in dealing with future applications. Secondly, consumer interests. This is quite complicated and detailed in the bill, and I may not be able to go into details today. Suffice it to say that in terms of contracts, there are stipulations as to the essential clauses and terms, especially agreements that are to be newly signed. How money can be claimed back, that would depend on the contracts. Maybe other departments can add in a moment. As for storage in domestic premises, I will have to defer to departments, but then the concept is to count domestic premises. PAS, consumer interests, and also subdivided units, please. Thank you, Chairman. As the DS explained, the notification scheme cannot be 100%. There are constraints, and not all the information can be accurate, but we have tried to be very cautious. The operators had to report to us, say if they also have a furnace and how many niches they have. We asked them to report to us. The FEHD did go out and take photos and keep records. They took photos of the niches, the area covered, the building, the location. We know all that. That's the notification scheme. Secondly, consumer interests. The bill contains provisions providing for the content of future agreements. Ms. Chan talked about stakehold. It's like buying pre-completion buildings. Well, you can't expect the administration to take care of everything, and there must be caveat emptor, and so they need to watch out and protect their own interests. Maybe you can turn to page C1138, where you can see what the contracts should include. Please look at C and how you should carefully consider whether your interest is protected against financial risks involved with a lump sum prepayment for an interment right for a long period. There will be different operators, and purchasers can go to different operators. If the operator can provide a stakehold or a fund, consumers would of course prefer such operators. We'll leave this to the market, the operator, and the purchaser. As for domestic premises, please go to C858. We have discussed with the buildings department before we decided on the definition. We are talking about premises used solely or principally for residential purposes and constituting a separate household unit. We have also taken reference from other ordinances. If it is a separate household unit, it must be just for one family, but we have to accept reality. A very short response. Number one, those who did not cooperate and who did not allow you to enter must have a high chance of breaking the law, so you need to be cautious. And secondly, stakehold, I hope that can be included in the contract so as to make it more secure for all parties. Thank you. Mr. Junius Ho. Chairman, I'm not sure about one point, and I have not looked at the bill. I'd like to clarify the definition of relative in paragraph 25. Is it in the PowerPoint? Page 22, please. Can I please clarify this? Who should be a relative? Now, who should be allowed to take care of the articles of a deceased? Now, first of all, it must be the estate executor. That is the proper one. As for the niche who entered into the contract, and about the spirit of contract, it must be the purchaser. And extending from these, there can be authorization, and the authorization must be from the purchaser or the estate executor or administrator. Talking about relative, if the relative cannot administer the estate, is it that we can give them more discretion? If you are the parent, a sibling, a spouse, or nephew, and if you can prove that you are a relative, I can allow you to do it. Even if you are the estate administrator or the purchaser, and you don't even have any authorization, then is it that as long as you can prove you are a relative, I can allow you to do it? But if you talk about relative, what about cohabitees? What about common law spouse? Some laws recognize them as couples. That I can understand also. And then, extending from that, what about same-sex partner who have got married overseas? I know that is very controversial. I know the committee has discussed this before. In your footnote, you say that if it is a fiancé or a cohabitee, or if a same-sex partner who has been married to overseas, then he can be the authorized representative. But once the person has died, the authorization ceases. I can understand that if you define it as a relative and use the traditional definition, that is all right. But then you are not looking at the authorization. Are we talking about relative plus authorization? How do you define that if you're going to use that? As I said, talking about authorization, either you are the purchaser or the estate administrator, you always have the legal right whether or not you are a relative. But you go for relative or something like relative plus authorization, then it is neither fish nor fowl. Yes, you can have special consideration for relative, but do you really regard same-sex partner who is married overseas? That can be very problematic. I have not really read the bill, but please, I like to get more information. PAS, thank you very much. About claimant for ashes, the authorized representative may be the purchaser, but sometimes the purchaser will also be the dedicated person, and this person can actually authorize a representative in the agreement that someone can take care of the ashes after he is deceased. And we will act according to the wishes of this dedicated person. Of course, there are relatives, purchasers, and also the, as I said, relative is clearly defined. Actually, under Hong Kong laws now, spouse does not include same-sex partner getting married overseas, but there is a view that we should consider it. We actually did not propose that CSA. The member is correct. We try as much as possible for genuine claimants to get back the ashes, whether it is the purchaser or the authorized representative, that are acceptable to many people. And then about relatives, there is priority assigned to claimants under relatives. When we come to clause-by-clause examination, we'll give you a detailed account. Members, 4 more members would like to ask questions. Our meeting should end at 10:30 because there is another meeting that will take place here. I need to reserve 5 minutes to take care of house matters. Any other members who would like to ask a question? Holden Chow, any more? If not, I'll draw a line there. All right? Mr. Leung Yu Chung. Thank you, Chair. Since we have received a letter from the Hong Kong Columbaria Merchants Association Limited, which says that there are many items or views that have not been clarified and they would like to still express their views. And as to Mr. Junior's Ho's points, all of those have been mentioned in the last session, and that may hinge upon the EOC jurisdiction. I think many deputations would still like to ask questions. Are we going to hold a public hearing, please? That's the first point. You may want to process this in the last 5 minutes. Secondly, a question for the administration. Slide number 23 and 4. If ashes are not claimed after a certain period, the FEHD can exercise discretion and dispose of the ashes in an appropriate way. And then you also say that with regard to government-operated Columbaria, they will not be regulated as such, but they are exempted. Today we are discussing private Columbaria. This is precisely because there is a gross lack of government-operated Columbaria, and that is why we have so many problems. Are there ashes that have been left there for a long time in government-operated Columbaria? And have you disposed of those ashes? If you have, there will be a much lesser demand for private Columbaria places, because I expect niches to be vacated in government-operated Columbaria. DS, let me first clarify. Actually, in slide 23 and maybe 22, when we talk about disposal of ashes, what are we talking about? After the bill is enacted, when we have a licensing system, maybe there are private Columbaria which cannot succeed in applying for a specified instrument. They may wind up and the ashes have to be handled. The bill provides for this in very much detail. Here, the claims are about this kind of ashes. The ashes are displaced, but they are not claimed by the purchaser, owners, or any agents. The law then authorizes the director of FEH to exercise discretion. And we are only talking about this part.
For public Columbarium, there is no such problem because public Columbaria will not close down at all. So there won't be this problem. But then the member made a good point, and that is in the supply of public Columbaria niches, we have to work harder. And indeed, we are doing a lot of work we have updated the relevant panel at LegCo on the latest progress. Well, can you simply tell me, of course, I know that the public Columbaria will not close down, but then some descendants will not continue to go and worship the ancestors there. Perhaps after many generations that won't happen. So then the ashes are just placed there and they are taking up space. Well, even if you're not closing down the Columbaria, there may still be ways for you to deal with these kinds of ashes, and then space can be vacated as a result. Can you tell Mr. Lang, through the doing the things suggested by Mr. Lang, how many niches can be vacated? So can you say sort of a system where people can where you will deal with ashes not attended by anyone, say on a 5-year, 10-year basis or what? The public niches validity period is indefinite. There is no prescribed period. I'm afraid I can't do that. Well, we can't say that if, say, people don't visit the niches in 3-5 years and they are left unattended and we have to displace the ashes. That can't be done. Sorry, the speaker is not coming through. Please speak to the mic. Yes, as what the DS said, many views told us that it would be difficult for us to do this, and there is no consensus. So I think that has to be dealt separately from the private Columbaria bill. I think we should first forge consensus on how to sort of have a healthy turnover of the public niches. Mr. Edward Lau. There are exemptions and exclusions under the bill. So the exemption for domestic premises is that they should meet with the criteria of keeping no more than 10 containers of ashes. But there are some traditional industries or sectors which will keep ashes for people. While the undertakers of burials will try to help you with exhuming the ashes, and after that is done, maybe a private niche is not available, so these undertakers will keep the ashes for you and for the time being. So should these traditional sectors be exempted, they may keep more than 10 containers of ashes. You have finished your third question? Yes. Who to take that question? As explained before, for those sectors or premises which are already governed by existing laws, and they will be exempted. So one of the sectors is the undertakers of burials. We have a different licensing system for them. What we are dealing with now is places where ashes are placed on a transient basis. Well, for the undertakers of burial, they are great in number, but they don't fall within the current bill. They are subject to another licensing regime. Understand? We talk about these undertakers of burial, and they are not very much mentioned under the bill. They are licensed, right? They are subject to other regulations, and they do not come under the bill. Well, if that is the case, then they can rest assured. Ms. Wang. Some of them will be covered under the undertakers of burial licensing regime. Then we'll go by 132. But then some do not come under that regulation. So, for example, for the stone masonry, we will have a special arrangements with them. These people will exhume the ashes, cremate them, and dispose of them. Very often, the relatives will claim the ashes back. We have administrative arrangements. After the ashes are cremated, they will be sent to the C premise facility under FHD, and then will be claimed back by the relatives. So this is a kind of administrative arrangement in place. In future, when we communicate with the sector, we will discuss what is the best approach. I'm talking about the stone masonry sector. You have not communicated with them. How can you say that you will communicate better with them in the future? You have never talked to them. Chairman, we have talked to them. In July, when the bill lapsed, we did meet with the sectors, and they indeed suggest this point, and we've been talking to them. We will continue to do so in the future. So we will see how the administrative arrangement can address their concern. Mr. Lau, maybe later on I will follow up. Dr. Lo Wai Kwok. Chairman, I have a suggestion. This was not the first time that the bill was introduced here. As what is stated in the paper, the views of the former Bills Committee and also various groups have been incorporated by the government. So a total of 547 CSAs were proposed, and all these have been incorporated in the latest version of the bill. We want to understand what these CSAs about. We can look at the electronic copy of these CSAs and go to the website. Well, I think the best approach is to do a summary of these CSAs. Maybe these 547 can be grouped into certain groups, address certain concerns, and the concerns have been dealt with. So if we can have a summary, then that would enhance our efficiency in scrutinizing the bill. Especially this time around, we have some new members, and maybe they have a certain views and concerns, and maybe these concerns have been addressed in the last session already. Then that can help speed things up if we have that summary. Now, if we have dealt with the public views already, it may not be necessary for us to hold public hearing. Slide number 8. And it is stated that the Columbarian premises should be held directly from the government under a lease, but then there will be a certain flexibility, and that there is also this requirement that the operator must have the right to use the premises for at least 5 years after the license has been granted. At least 5 years. This refers to pre-cut off Columbaria. But for newly licensed Columbaria, there is no this requirement of 5 years. They have to hold the premises directly from the government under a lease. Well, that's exactly my question for the pre-cut off Columbaria. They must have the right to use the premises for at least 5 years. At least 5 years or at the most 5 years. Yes. Well, perhaps we can make the wording clearer. What we meant is that the operator must have the proof that he can at least use the premises for at least 5 years. Maybe he has a tenancy, then there is only, say, 1 or 2 remaining years of his lease under the tenancy. Then that would not be accepted because we are trying to protect the interests of the consumers. Well, you mean that the operator has a right to prove that he has a right to use the premises for at least 5 years. But anyway, I raised this suggestion with they consider it about the suggestion about the summary. The paper is already in existence. If you in the second page of the agenda, paper is already there. CP bracket 2345 stroke 1617 bracket 05. But they are in several hundred pages, so we've not particularly printed that out for you. I'm not asking for several hundred pages of a document. What I want is a summary, and it's just very simple. Try to explain how you incorporate the views of the LegCo members and public, and what responses have you made, etc., etc. I think a summary will help. The PAS, any response? We did consider that, and later we will discuss with the Secretariat on how to draw up this document. It will be more succinct and concise in laying out the major concerns and how we respond to the concerns through the amended provisions. Now, maybe some of the members here are new, and maybe we will be repeating points made by others previously. So if we've got the summary, then we may not be asking so many questions. In the last Bills Committee, we moved 547 CSAs, and the CSAs have been incorporated into the latest bill. Do we believe that the governor has indeed done so? But then if there is a table or summary showing that these 547 CSAs have been incorporated, and in which sections particularly, then that would help facilitate our scrutiny of the bill. Dr. Lowe, is this what you are asking for? On top of that, you should set out the concerns expressed by the LegCo members and the public, and how you have dealt with these concerns accordingly in your bill. Or Chairman, well, it will be not so good if we list all the 547 CSAs. So we try to categorize the different concerns and then set them out. Do you agree with that approach? Yes. Okay. So after the meeting, the government and the Secretariat can work together and work out a simple and concise document for our reference. Maybe you may not have to do it all at one go, but in phases as we go along in our scrutiny. Mr. Raymond Chan, of course I agree to that. I hope that they can come up with a summary. Please be succinct and don't make it say 500 pages. In the Corporate Amendment Bill, if I remember correctly, well, that straddled across 2 terms, and they did some tables and summaries as well, especially on those particularly controversial issues that can facilitate in our discussion, so that we will not start from scratch in our discussions. I don't agree with Dr. Lowe's suggestion that we don't have to hold a public hearing, though. The Hong Kong Columbaria Merchants Association Limited said that although the 547 CSAs have been incorporated, they still have difficulties or questions on how the bill will be implemented.
And I also understand that some sexual minority groups would like to speak up. The Bills Committee should act like a platform. If the administration cannot receive any deputation, we here should operate a public hearing so each will have 3 minutes to express their views, and we can invite submissions from them. The legislative purpose of the bill is to regulate private columbaria and combat illegal columbaria. We are not trying to make life difficult for consumers. Our main concern is if there are columbaria which operate illegally and they do not meet legal requirements and then in the end they collapse, how can the descendants who are made victims be helped? We should not make life difficult for such descendants and put barriers on their way. They have paid, but the columbaria collapses, and then it will be very difficult for them to claim back the ashes, and also in a very undignified manner. Some members have asked whether the definition of relative can be relaxed. I understand that is controversial, and I raised that in the panel with Mr. Coingman, the Secretary, but he asked me to bring this back to the Bills Committee. I'd like to make a few points clearly here. Some ex-members said that if a same-sex partner has got a marriage certificate overseas, it doesn't amount to changing the definition of spouse. The member was just trying to make the definition of relative more detailed. Talking about discretion, of course, if after many procedures no one claims the ashes, and if someone comes in to say, I'm his husband, we married overseas, I'm sure the director of FEHD would exercise his discretion instead of throwing away the ashes. That I understand. But we are talking about people's interest. At that time, the administration objected, and it objected when the member moved it, and in fact the president then accepted it as a CSA, so members could debate it in council. Now some time has lapsed. Have you reconsidered the issue? You have not included it as one of the 547 CSAs, and I know that means you do not accept it. But have you reviewed the situation internally, whether there is still room for discussion? Diaz? Thank you, Chair. We have indeed considered Mr. Ray Chan's point. As Mr. Chan said, if we amend the definition of relative, indeed, that would be very controversial. When we did the introduction, we also mentioned this point. We want to point out that in the bill, there is already a lot of flexibility. We don't want to make consumers victims. If there is collapse of a private columbarium and people have to claim back ashes, that is already very unpleasant, and we want to make it less difficult. I don't want to go into a detailed controversy today. I just like to make the point, when we amend the bill, we want to make it more perfect. If you pass the bill and someone takes it to court for a JR, that's not something we want to see. Say, for example, if it is a partner, if that is a de facto relationship, whether or not there is a marriage certificate, if he dies and I want to claim back his corpse, I would be able to go to the court to for a JR if you refuse it. So I hope you will consider it. Mr. Holden Chow. First point, on the definition of relative, we have to approach it with caution. Same-sex partner, if it is included into the definition of relative, whether there is marriage overseas, then it would be a backdoor way to recognize same-sex marriage in Hong Kong. we need to exercise a lot of caution because it will spark a lot of controversy. It will also deal a big blow to traditional family understanding and also traditional marriages. I would go by what is proposed in the bill, and that is same-sex partner can be an authorized representative. The status is an authorized representative, and it doesn't need to be included in the definition of relative, because once that is done, it is like recognizing same-sex marriage in Hong Kong. That is the de facto situation. It will do a blow to traditional family values and our marriage system. Second point, in the paper, you say that in terms of consumer protection, the consumers can enter into written agreements with the seller, and all the terms will be set up, and if there is irregularity, the contracts can be cancelled. Well, I'm thinking of some worst case scenario. Say if there is no sale and purchase, but there is only a tenancy. In other words, people try to circumvent selling and purchasing. Would that still be regulated by the law? Now, I'm not trying to be difficult, but there are people in this world who want to make use of the loopholes in the law. So if there is no sale, can your provisions still protect the consumers? And also, if after a certain time of operation, if there is a gross situation of irregularity and if there is a collapse, what kind of cancellation of contract can take place? Will there be guidelines saying that the purchaser will be able to get full compensation? Or as lawyers, we know that even if there is cancellation of contract, there can be different scenarios. Some would allow you to rescind the entire contract, but some don't. P.S. Chairman, first point. I'd like to talk about renting out or hiring of niches. The law says that the selling of interment rights includes selling of the niche and also renting out the niche and how payment is done. That is all provided in the law. If there is a collapse, we are now formulating the guidelines. And as for compensation, if there is cancellation of agreement, the purchaser can recover the money. There are provisions in the bill. Whatever is paid can be recovered, but of course if it is not paid, it cannot be recovered. Well, of course. So basically there can be full recovery. Even if the service has been used for some time, if at some point there is a serious irregularity or a collapse, all monies can be recovered. Well, no, we have to be fair. If the niche has been used, there is only a remaining validity period. In Part 5 of the bill, it says if the niche has been used, and if there is reselling, the price may be lower. So according to the agreement, arrangements can be made. I understand. Okay, is that okay? Yes. Today, we have had the first discussion on the main directions of the bill. Of course, there is a lot of concern in society and people want us to pass the law as soon as possible. The administration has got a work plan. Could I ask the PAS to introduce the paper to us? Or DS, please. Chairman, as you said, there has been very detailed discussion of the bill before, and there are many provisions in the bill as well. We therefore would like to propose a work plan so that we can go into clause-by-clause examination ASAP, and the details, in fact, can be left to clause-by-clause examination. We would like to take the bill to you part by part, and of course the parts themselves are already full of details. Members, can I ask you to look at CB bracket 2345/16 to 17 bracket 03. Our next meeting will still be devoted to general policy matters. If members do not object, we can then proceed to clause-by-clause examination. I hope we can have about 8 meetings, including this one. And I hope then we can complete clause-by-clause examination, and then hopefully on the 24th of February, we can submit a final report to the Bills Committee, to the House Committee, and on the 22nd of March, we can resume second reading debate. That is the rough direction. Can I please ask for your cooperation? And so, okay, we have completed this part. Item 3, AOB. Just now, a member proposes a public hearing, and I'm aware that some other members agreed. There is a letter from the Hong Kong Columbaria Merchants Association Limited, and they would like to meet members. However, when we discussed this at the House Committee, there is the alliance with private columbarium concerns asking us to pass the bill as soon as possible, and they actually said that no bills committee should be formed. I'd like to strike a balance between these two views. Dr. Priscilla Leung, did you raise your hand? Please be very brief. Yes, Chairman. Hong Kong is a disaster area, but we have residents on both sides. Residents would very much like to pass the bill, and I also support that view. However, we spent 2 years on the bill before on the various details. Reading this letter, it is asking for more communication. Maybe you can decide whether we should have a public hearing, or we can meet with them somehow. The letter is right in a very cordial manner. This is a new term of LegCo. Of course, we want to pass the bill ASAP, but where possible, we should try to meet the association. Okay, it's almost time. Holden Chow and Ray Chan, please be very brief. Chairman, my view is, according to the paper, the last term of LegCo went through all the procedures, and the bill has taken upon all the CSAs after the discussion in the last term. Do we really need to reopen the discussion, Mr. Ray Chan? What is not to reopen discussion? If you want a public hearing, it can be combined with our next meeting. If 8-10 deputations come, it won't use more than an hour. I think we should allow those who still want to speak up to come. We are just talking about one meeting or so. Okay, I only have one last minute. I'd like to summarize our discussion like this. Many members and people who are concerned, in fact, came in the last session. Let us compromise by doing this. We'll ask all concerned parties to make submissions for the consideration of members. Would you agree? There is this opportunity. Well, if you do not invite them to come, they can still write submissions all the time. I'm just asking for a platform to allow them to speak for 3 minutes. Well, extend the meeting by 5 minutes. Mr. Leung Yu Chung and then Leung Kwok Hong. Chairman, read the letter. It says they still would like to speak on many points. I think it's better to give them the opportunity. And the administration will have to answer right away. If it is in a written form, it is unidirectional. Leung Kwok Hong? There are too many stakeholders, and the questions have been here for a very long time, and different proposals have been made.
If you've got the bill wrong and you miss something, then it's even more troublesome if you have to rework it. And some people said that we've already got the job finished at the last term. I object to passing this bill in a rush. There have been certain delays in the last term, and coming to this term, you said that we should just pass it. That's not right. Dr. Helena Wong. Chairman. Well, we should have different ways of doing things at different times. The chairman has changed, members have changed for this bills committee, and if deputations are invited to come up and express their views on the latest bill, then I think we should. That's good, and I think if at a public hearing we can ask them questions directly. I object to just going by way of written submissions. I don't agree with Mr. Leung Kwok Hong. Last term, we scrutinized the bill clause by clause, and we finished our work. It's just that the bill wasn't dealt with ultimately at the last term. I don't think we are doing things in a rush. I think we have done our best job. Now, there is still a letter raising certain queries. I can understand that. Even if we have done clause-by-clause scrutiny, not everyone would say, tune in to each and every meeting. The same goes for myself. So if they have queries from this, we have queries from this association, I'd like to know whether the administration has talked to this association. We've been liaising with the sector all along. And if we know that there is a certain group having certain views, we are more than happy to listen to them, well, especially on how to implement the bill or the ordinance. Mr. Leung, if there are quite a number of people who have queries, and I think we should do a public hearing. But then should we just have a public hearing if, say, someone raises a certain question? I suggest that similar to what we're doing at the complaints division, they can meet with the members, and that's it. Well, I have heard your views. Well, there are quite a number of members in the Bills Committee, and some members may be engaged otherwise and are not here all the time. So maybe we will defer a decision on whether to hold a public hearing at the next meeting. And in the meantime, maybe I can ask the clerk to invite the deputations to give written submissions, and then we'll decide whether we will hold a public hearing at the next meeting. Date of next meeting, in view of the tight schedule, we would suggest that we hold the meeting at 4:30 p.m., 20th of December, 4:30 p.m., a Tuesday. If the clerk writes to deputations to ask for written submissions, perhaps we can ask them whether they would come and here to express their views. Then we will have a better grasp. So, meeting adjourned.